We're going to sort through and start with what I think most people are here for, and that's going to be the basic topic of conversation. We're going to start with Proposition 19, and then we're going to roll through some other stuff. You're probably not as interested in that, but let's start off with Prop 19 and see how we do. So, as of February 16th, there no longer is a parent-to-child exclusion for investment properties. Anything except a principal residence is an investment property. There are some weird rules that we're not quite sure about with regard to second homes. Right now, I think we're just going to talk about one primary residence. And with regard to primary residences, we have an exclusion that can come into play if one of your children decides to live in your principal residence. You have to be living there, and then they have to be living there. And here's how it works. Whatever your assessed value is, not your fair market value, but your assessed value, you can find that on your property tax bill. You get to add $1 million to that number. And if your fair market value is less than that number, there will not be any increase in property taxes. If, on the other hand, your fair market value is more than the assessed value plus $1 million, there will be an assessment to that extent. So people who are living on the Strand, where they have like an $8 million difference between fair market value and assessed value, they're not going to get much protection. They're going to have a huge property tax increase. For most people, however, the increase is not going to be that severe, depending on what the value of their home is. With regard to people, if you're thinking, did you make a mistake by not gifting prior to February 16th? And a lot of people we talked to, when we really described what the real situation was, they decided, you know, it's better not to gift. And we're going to talk about an income tax term known as basis. When you sell a piece of property, in order to determine gain or loss, you need to know what your basis was. And basis is usually what you bought the property for. If you bought it for 100,000 and you sell it for $1 million, your basis is 100,000, you sold it for $1 million, you have a gain. When you inherit property, you get to pretend like you bought it for fair market value as of the date the person died. So that's called a step up in basis. It can also be a step down in basis, but here in California with real property, we always talk about in terms of step up in basis. However, if you gift property to somebody, they take the same basis that you had. So if you bought your home for $100,000 way back when, and it's now worth $2 million, if you gifted it, they're only going to have a basis of 100,000. Or if they could have waited for you to die, they would have had a step up in basis equivalent to 2 million. So if they turn around and sell the property, there's no income tax to pay. For the determination as to whether or not Prop 19 comes into play, it isn't the date of recordation of the deed. It's either the date that a person died. So if anybody died before February 16, you don't have to worry about Proposition 19 at this point for that transfer from that person. And if in fact you have a document that is notarized before the 16th of February, the LA Assessor's Office has indicated they will accept that as the date of transfer. The reason is the Recorder's Office is about 2 months behind in getting deeds recorded. So if you have a deed that has a notary stamp, now I've had a couple situations where people have been on lockdown and we can't get notaries in. So what I told those people was just get it signed by the person and then scan and email it to several different people so they know that it existed. The person actually signed it, even if it didn't get notarized. They had signed it before February 16th. There are so many unanswered questions right now about Prop 19 because the Board of Equalization, which is the statewide system for property taxes, they have not yet come out with any real regulations to give us a lot of guidance. But with that being said, I'm going to open it up to questions now just about Prop 19, because I think that's what most interests people right now. So I don't know how to deal with the order of taking questions. Barry McCabe, do you have any solution there?
If somebody could just raise their hand and we can call on them. Like Sherry, go ahead.
Well, you pretty much answered it because Prop 19 was my concern. When I die, I want my daughter to inherit the property, but she doesn't want to live in Southern California. So that's my big concern, what's happening. And I was hoping for some answers this year, but you just said the Board of Equalization hasn't made any decisions yet. So I guess my question would be, do you think there would be any resolution that would be favorable to my current situation or my future situation? How is there any discussion regarding the possibility of making it easier for?
Here's a trick that you probably don't want to use, but this is a solution. You now with Prop 19 can change your principal residence and still take your same low property tax base. So if you move somewhere where your daughter does wish to live, then she could move into your house.
Right.
You don't want to leave Southern California.
Hey, I don't want to leave it. That's right.
But that is a solution for you. Okay. So just before you die, if you want to go change your principal residence, which I'm sure living in your house, you have no collectibles or anything, it'd be so easy for you to transfer your principal residence. That's what was so absurd about Prop 19. Nobody in their right mind is going to change their principal residence multiple times after they're a senior citizen. It's just too much work. You know, we're old. We don't want to move our principal residence even once, much less twice, but that would be a solution for you. Hopefully, Californians wake up and realize that they didn't really understand all of the moving parts with Prop 19. And maybe it'll be on the proposition ballot a few years down the road. We'll see what happens.
Okay, thank you.
Welcome. Separate property. Community property. The beauty of community property here in California, we're going to relate back to that thing called basis. And in California, for married couples, if either spouse dies, both halves of the property get a step up in basis. If you live in a separate property state, only the dead person's half would get an adjustment of basis. So if in fact you had a spouse who died recently, it might have been more attractive for you to actually have gifted the property prior to February 16th. In the world of estate planning, why is it even important for us to know what's community and what's separate? Well, everybody has control of 50% of community property, and anything that's their separate property, they have 100% control over. Now, if you have kids and it's all going to be dumped in one pot, probably doesn't matter a whole lot. If, however, all the kids and grandkids and you die, now all of a sudden it does become important because you're probably going to have your stuff go to your side of the family and your spouse's stuff go to his side of the family. Now it kind of does matter what is separate property. Let's go to separate property for a second. What can be considered separate property? Well, anything that's inherited or you received by a gift during lifetime, and it's way better to receive appreciated property by inheritance. And if you're making gifts to people, make gifts of cash or property that has not appreciated very much. That's just kind of a rule of thumb. If you own assets before you were married, those are separate property items. You can keep things separate within a joint trust, husband and wife joint trust, maintain separate property. How do we do that? We just have one trustee instead of both trustees owning that property. And which person is that? It's the trustee who has the separate property. So just because you have a joint trust does not mean that you can't have separate property within the trust. Can you convert community property to separate property? You can if you wish. I don't usually see a point in doing that. You have much better protections usually as community property from a basis standpoint. Most of the time, it's separate property gets commingled, and now it's community property. You just lost your separate property aspect. And if you can trace separate property, you can still maintain it as separate property. For instance, you inherit $1 million and you put that down as a down payment on a house. That is easily traceable. So if you ever got a divorce, you should be able to get that $1 million back. No interest, but you at least get that $1 million back before everything else is divided. So let's switch over for a second. Everyone's heard the term probate. It's just opening a superior court action to wind up the dead person's affairs. And it really isn't that tough usually to wind up a dead person's affairs. You pay their taxes, you pay their last bills, you distribute their stuff. Not a big deal. However, in probate, you have a lot of additional expenses that you probably would not have if you had a trust. And we'll be getting into some of the ease of administrations as well as the costs that can be avoided. When you have a probate, the executor is entitled to the same amount of fees as the attorneys. Now, quite often they don't take their fees because that's income taxable. But if you have a third party administrator like a bank or somebody, they're clearly going to take fees. You have your filing fees. They used to have just one filing fee and you're good for the whole case. Now, every time you file a petition of any sort, it's an extra $465. The accountant fees and appraisal fees, you'll probably have those with trusts. Let's take a quick look at what the actual executor and administrator and attorney's fees are. And let's start with, they look at the gross number. So if you have $1 million piece of property, but you owe $900,000 on it, it's not counted as $100,000. That's your equity. It's counted as $1 million. And if in fact you had just one piece of property that was worth $1 million, and that was what had to be probated, the statutory fees are $23,000 to the attorney and $23,000 to the executor. And if there's anything that's extraordinary, like you decide to sell the property within the probate, that could qualify for extraordinary fees on top of the statutory fees. So the real detriment, however, from where I'm sitting, in LA County, it takes well over a year to complete a probate. That means nobody gets stuff until that time has expired. Your kids aren't going to get anything until the court says final distribution. You also lose privacy. Living trusts are wonderful for keeping things private. And if you happen to have properties in other states, you would have probates here in California and then ancillary probates in each state in which you hold real property. By real property, I mean real estate. If you happen to have a stock account in New York, that's personal property. So that doesn't count. You don't have to open a probate in New York just because that's where your stock account happens to be. I want to stop for just a second in case somebody has a question about probate before I go on to living trusts. Cool. Let's go next. How to avoid probate. A living trust, I just tell my clients it's a will substitute. Does the exact same thing a will does. It just doesn't have to go through the 1.25 year-long probate. Now, that doesn't mean you might not have a trust administration for an equally long time, but the assets aren't tied up for that period of time. You can pay for all sorts of stuff during that administrative period. What could cause something to cause administrative period to lag? You have to file a death tax return. Now, right now, everybody has $11.64 million of death tax exemption, as well as gift tax exemption. You can gift 11.64 million while you're alive, or when you die, you can protect $11.64 million from death tax. Married couples, you add them together,
We've
you
never
got
had.
23 million. So most people do not have to be concerned with death taxes any longer. So probate is the major expense facing people. If you have a will, here's what the will does. It just, you receive the assets. It says who gets assets when, and it names people to make things happen. And if you have minor children, guardians get appointed through the probate court. With regard to living trusts, after people die, we have these sub-trusts that we usually form to protect loved ones down the road. You can have the same sub-trusts in a will as in a living trust. You don't have to have a living trust to have these sub-trusts, by the Q-tip trust and the bypass trust and the survivors trust and stuff like that. Unfortunately, you need a court to sign the order to set up these sub-trusts. If you have to have a probate and you set up these sub-trusts in your will. So you can have a will, it just gets a lot more expensive, et cetera, et cetera. The formalities associated with the will, they're actually starting to loosen up on those a little bit, especially in this day of pandemic where you can't necessarily get witnesses in the same room, social distancing, et cetera, or people are signing their wills in lockdown facilities. But you have to be over age 18. You have to be of sound mind. Now, you really don't have to be that sound of mind. You just have to know two things, and you have enough capacity to make a will. You may not be able to remember what you had for breakfast. That doesn't count. If you know what you own and who you are giving it to, you have enough capacity to make a will. You have to have a higher capacity to make a trust. So make your trust sooner rather than later, because if you get to that shade of gray area, it's more vulnerable to attack. You, of course, have to sign your will. And what's interesting is the witnesses don't have to be in your presence when you sign it. You just have to say, this is my will, that's my signature. What's weird is the witnesses have to be in each other's presence when they witness the will. It's better to have everybody in the same room at the same time when you sign it, but there's a little weirdness there that can occur. Now, the exception to that is if people just write out a will in their own handwriting, date it, and sign it. I have probably dictated 30 holographic wills when people call up and say, I'm going to Europe tomorrow. I don't have anything. I tell people, pull out a pen and paper. You ready? I hereby make this will. I so-and-so give everything to the following 6 individuals. Here's who's going to be my executor. I waive bond, sign it, date it, It's not the most efficient, but it'll at least get the job done. So holographic wills are perfectly legal. If you die without a will, there's a thing called intestate succession. If you are married, the community property will vest to the surviving spouse. The separate property, however, will be divided, and it depends on how many children of the decedent are alive. If there's only one child, one spouse, it's a 50-50 split. If you have one child and more, one spouse and more than one child, it's going to be a 1/3, 2/3 split. So if you have 6 children, they're going to divide the 2/3. The wife is always assured of at least getting 1/3 of separate property if no plans are done, no will, no trust. Sometimes the intestate succession can be a little tricky because if you have, let's say, 2 brothers or sisters, and one of them has 1 child and the other has 4 children, if only one of them dies, those children step up into the shoes of the deceased sibling. However, if both siblings have died, we now have a 5-way equal split, not 50% going to one child and 50% being split between the other 4. So if you happen to be the one child that survived the deceased parent, you want to make sure your uncle or your aunt survives your grandparent. Otherwise, you just went from 50% to 20%. You're going to be quizzed on this. So let's go to living trusts. Everyone's heard of living trust, just a will substitute. It avoids probate. But here's the real beauty of a living trust. It can help you while you are alive. Now, you could be powers of attorney also, but society doesn't like powers of attorney as much as they like living trusts. And here's why. A power of attorney is just one document that could be slipped in front of somebody and they sign it. A living trust, not only do you have to set up a living trust, but you have to start putting stuff into it. And that gives the title companies and the institutions, stocks, banks, it gives them a greater level of comfort to deal with a successor trustee rather than a power of attorney holder. So if you're incapacitated, you're going to designate who you want to be as a successor trustee. Things remain private. It's amazing how easy things can be if you don't have to go to court and wait in line for month after month after month. Now, that doesn't mean you might not end up in the probate court anyway. People can contest stuff. I've never had any of my documents contested, but hey, it's just a matter of time, I'm sure. Let's quickly go to the terminology associated with the living trust. In California, we call the person who's making the trust the settlor, and that's an OR. You're the person who is setting up the trust, and the California Probate Code calls you the settlor. However, if you happen to be living in New York, you'd be called the grantor, OR. And if you lived in Chicago, you'd be the trustor, OR. Whenever you see OR, that's you. And sometimes you're going to get forms from all over the nation. Don't get faked out. If it's OR, you just say that's you. You have a trust. You are the only person who's going to be a beneficiary if you have a living trust, unless you say otherwise. You can say, gee, I want 6 people to be beneficiaries of my living trust. I've never drafted one that way, but it's legally permissible. So you're going to be the only settlor, the only beneficiary, but your trustee can change. And this is the person who's going to run your finances. This is not the person who's making medical decisions, although you might have that same person be your attorney, in fact, for medical decisions. And then everyone has a different idea of who they think would be a good trustee. And I'm not saying my 2 points are the most important, but I've been watching from the sidelines for 45 years. And I think there really are 2 most important qualities for a trustee. Number 1, are they honest? That's a given. Here's the one that tricks most people. They're looking for someone with an MBA or an attorney or somebody who's really smart. No. Attorneys and doctors are the worst trustees because looking here, it's all about a function of time. So are you important enough to this person that they will find the time in their very busy schedules to squeeze something else in? They're not going to be reinventing the wheel. They're probably going to use your same stockbroker. They're going to probably use your same accountant. It's a function of time, really, more than anything else. I don't want the world's smartest man either, because he will never ask a question and things will get all screwed up. So get someone who's got common sense, who you are important enough to them, and they're honest. And I find that really works the best. A lot of people have living trusts, but do not understand how important enough it is to have your trust funded. By that, I mean you own the property as trustee of your trust. Remember, trusts can't own anything. Trustees always have to own it on behalf of the trust. So what do we put in the trust? Well, real property for sure. Bank accounts, for the most part, I usually recommend that one bank account be held out of the trust for a joint tenant to join you to maybe help you write checks for bills, get your Social Security check automatically deposited into the bank account. For some reason, I have never been able to figure this out. Half the time, it's not a problem for my client to have a checking account in their trust and the deposit is automatically made. And half the time, the Social Security office says, nope, we're not going to do it if it's in the name of the trust. So I usually just say, just keep a small checking account outside, and that works way better. banks give me the most problems as they give my clients the most problems. Why is that? Well, the bank people are not well trained. Every branch seems to have different rules. Here's what they are entitled to. They're entitled to a trust certification. They're not entitled to your trust itself. And some people will say, oh, no, we have to have your trust. No, actually you don't. There's a probate code section that is right on point. And in fact, we give our clients this little 3-page that Mary, by the way, Mary Corcodian from our office is the one that did this wonderful PowerPoint. You'd have had handwritten, who knows what, if it had been up to me. So if in fact, she drafted this little 3-pager it's really cool. And it basically, if they want to keep giving you garbage and they won't do stuff and they just won't accept a trust certification, you just say, what's your name? And okay, and you just write their name into this complaint and you say, will your manager accept service? And all of a sudden they get real nervous and they come over and son of a gun, you don't have any problems anymore. Because the complaint says, well, we're going to get a statewide injunction to make sure your bank follows the law. And the manager of the bank and that person sitting there does not want that to cross their plate, so they'll do what you're supposed to do. If you happen to have LLCs or sub-S corporations or other corporations, we put the membership interest in those legal entities, stocks or partnership interests. Those get transferred, not the underlying assets that are in those legal entities. And it's really, I don't know how important it is to tell you, look to make sure things are in your trust. Now, we've had a document in our repertoire for about 35 years now, I think. And I call it the lifetime cleanup document because you're on your deathbed and we discovered the 50 acres in Montana you inherited from Uncle Butch is not in the trust. Here, Sherry, sign this deed. And there she is in a coma. You're going to designate 5 people if you can, any one of which can sign your name to put your asset into your trust before you die. And I don't see very many attorneys writing this document. It's a piece of cake that has saved my clients, I don't even know how many, but I do know that in 45 years, I've only had to probate 2 of my clients' wills who have had living trusts. This document works wonders. And this is a speed document because once you die, this document evaporates. And if we didn't get the 50 acres in Montana into the trust in time, we're going to end up with a probate. Oh, did I mention that when you have a living trust, you also have a will, but the will serves a different function. It doesn't say who gets what when. It says this is a post-mortem safety net to capture all of the mistakes that didn't get put in the trust. And when it gathers up the 50 acres of Montana and all this other stuff, it says, pour it on over into the trust. And guess what they call this will? It's a pour over will. So whenever you hear someone say, oh, my pour over will, You know they have a trust. They go hand in glove. So let's go and tell there's some assets that you do not transfer into the trust. And in fact, if you try to, the people who are your custodians and stuff will probably go, no, 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 no. IRAs do not go into the trust, otherwise they would blow up and you'd have to pay income tax on the whole enchilada. Same with 401ks. And we don't have life insurance policies and annuities. We ask people to name the trustee of their trust to be the primary beneficiary of life insurance and annuities. Now, IRAs and 401ks are a little trickier. You actually have to do a lot more analysis. And we're not going to have enough time today to go into that analysis. But individuals who are named on IRAs, they get a 10-year window period to cash out, where if you name the trustee of the trust, it's only a 5-year period in which to cash out that IRA. But usually the advantage of putting it into the trust is then you're allowed to transfer it to the next generation in what I call a protected vehicle. What I have set up for my daughter is it's a trust for her benefit for her entire lifetime. But she gets to become her own trustee at age 30. And so she has the keys to the vault. And many moons ago, I used to say, let's distribute 25% when they hit a certain age, and then maybe another percentage when they hit a certain age. By the time they hit 35, let's distribute everything to the child. And I learned the error of my ways. People get divorced after they're 35 years of age. And if I want to get the maximum protection for my daughter, it's going to be in her Brittany Lee Baker irrevocable trust, with her being the trustee. And as long as the assets stay in that trust, they're creditor protected, they're divorce protected, and they're, to a large extent, going to be death tax protected. So if you have your IRAs or 401ks going into the trust, then you can put it into that child's trust, where if you just name the child, it ends up in their lap, and they can't set up their own trust and fund it with their assets and get death tax protection, get creditor protection. They can still get divorce protection if they're good enough of keeping things separate. But it's way easier if it stays in that bulletproof trust to make the argument, no, it's not commingled. I did family law for 15 years. I know the arguments that can be made even if assets are only in one person's name. So probably chat with your attorney about IRAs and 401ks, although you're going to have to chat with your plan administrators if you have things like 401ks, because that's ruled by contract, and there's like 8,000 different contracts out there. So ask the plan administrator, what are my post-mortem options? When I die, does everyone just have to take a lump sum? Does some people get to stretch it out over their lifetimes? Get that information first, and that'll help guide you on how you want to name your beneficiaries. So, how often do you have to look at your wills and your trusts and stuff? I have clients who don't look at them for 25 years and they still hold water just fine. If you want to change who gets stuff, or if you want to change who the power holders are, and that's your successor trustees and maybe some people called trust protectors or special trustees that are out there. You probably don't have to do a whole lot. Keep your eye on the ball, though, if there's things like portability that come onto the scene. Portability is something that's really cool. Don't have time to go into it right now. But portability saves those people who did not plan. The married couples who did not plan are now saved by portability, but only if they're awake enough to take advantage of portability. And they've got 9 months to take advantage of it. I'm just putting it out there as an issue. Can't discuss it right now. We have exhibits on our trusts, and people are always giving me a call, say, hey, I have a new house. I need to change my exhibit. No, you don't. The exhibit was just a snapshot as of the day you signed your trust. So then how do I fund my trust? You buy that asset as trustee of your trust right from the get-go. That's what the escrow, boom. Sometimes the lender says, sorry, you have to buy it as an individual. Okay, buy it as an individual. The next day with the grant deed, just transfer it to yourself as trustee of your trust. And that's the way to run your business. If you want to become a member of an LLC, right from the get-go, take the membership interest as trustee of your trust. Pretty simple. You can have the greatest plan in the world. And if you don't hold title correctly, title overrides all of your brilliant plans. And what kills me is joint tenancy. Joint tenancy, people come to me and things are in joint tenancy. And here's the issue. Was the surviving joint tenant on that bank account that was $250,000 as a matter of convenience to help people pay their bills or whatever? Or were they truly supposed to receive whatever was left in there as the surviving joint tenant? And people ask me, which one is it? And I'm going, how the heck do I know? What did the person, in fact, intend when they added a person? So spread the word. I still want you to have joint tenants on a single checking account or something, but let the world know by email, because emails are traceable. And you send the email to all your kids saying, I'm putting son number 3 on the checking account with me as a matter of convenience. Everybody knows whatever's left in that checking account doesn't go to the surviving joint tenant. And if you have property, you have a living trust and everything's wonderful, but your piece of property is in joint tenancy, it's going to go to that surviving joint tenant, not pursuant to your will or not pursuant to your trust. So don't undo all the great things you've accomplished by holding things improperly titled. I think I've hit the end of what I have to convey at this particular point. I do want to make a pitch for H.E.L.P. They get about 30,000 hits per month, maybe more now the pandemic has hit, on their website for free advice, for free forms, to guide people to resources so they can figure things out themselves. And it's just a really efficient organization. You get a lot of bang for your buck if you support H.E.L.P. Their administrative overhead is extremely low for what they do. It's Artist that takes all the money. Oh, wait. Artist, did you hear me? Artist is the go-to person at H.E.L.P. And she's wonderful. And Britt Huff, we couldn't ask for a better
Yeah,
executive director.
sorry, I was muted.
Well, but I thought you'd at least be shocked looking if I said you take all the money.
I thought I was on. Okay, I'm sorry.
So,
Brad, your question again.
well, it wasn't really a question. I was just making an untrue statement.
Oh, okay.
Okay, so they promote all sorts of handouts. We get a lot of people from out of state whose parents are here in Southern California and they're in Ohio and their parent needs some help. And H.E.L.P. is spearheading what I think is a phenomenal, it's probably taken a backseat to our pandemic. I hope it's called the village concept. And people within their own neighborhoods help seniors who are not very mobile, who need maybe the trash to be taken out once a week. Maybe take their mail from the mailbox into the house. Maybe just drive them to a doctor's appointment. Simple things. Getting the sink fixed. There's a group of handy people who have been vetted by the village that you can call and they can help you out. And this keeps people in their homes a lot longer and gives a tremendous quality of life that wouldn't exist without this village concept. And I know that H.E.L.P. is helping Palos Verdes and the South Bay. They each have their own organizations. And I'm sorry to say I haven't kept up with how that they've been more effective during the pandemic or if it's been put on the back burner. But this is something I would like people to look at and get their friends and neighbors to look into that and see if maybe they could donate a couple hours a month to helping someone in their neighborhood. This, how come it's not my picture?
That's our website.
Oh, okay.
It's one of the things that comes up on the website, one of the pictures, but this gives you an idea as to what our mission is, what it is we can do to help. We're sort of a repository of information on all subjects as best we can, and also information on referrals to other organizations that may be able to directly assist. We get a whole wide variety of questions on just about every topic imaginable, from raccoons in the backyard to, we don't answer legal questions. We're not attorneys, but we can recommend those instances where you need to get legal help and where to find it. Also, general information, because we get a lot of inquiries about government programs. What's the latest and greatest on the various things going on in the community. And we try to get people connected right now, more important than ever, because people are not able to get out and about as they normally would. So many of our clients don't have computers or don't have a computer access. So we're able to give them phone numbers in many instances that they can call to get help. We try very hard to answer every question that comes in. And sometimes we have to send information after the fact, but we will definitely research it. We've been getting an enormous number of out-of-state calls of late as well. And that's always challenging because we're not always sure where to find the help in those states, but we usually manage.
Cool. Thank you very much, Artis. I can't remember if there's anything else. There is. Lots of nuts and bolt guides are available for free. So refer people to the H.E.L.P website. It's a tremendous resource. And we're very lucky to have them right in Torrance. So let's see if there's anything else. We thank you for your support. Any last minute questions?
Can I get your name?
My name
Yes.
is Brad Baker, B-H-A-E-R.
Okay.
And I've
And
been
where
with-
is your office located?
it's Tijuana. No, actually, it's Hermosa Beach.
Okay. Thank you.
This Sherry. Yes, Sherry.
Hi, Brad. I am really impressed with your delivery and the information, and I just wanted to tell you.
Well, thank you very much. That's very nice. Thank you for the kind words.
Appreciate it.
I've been doing this a really long time.